Good afternoon. Welcome to today's Brachers Bitesize webinar. My name is Colin Smith. I'm a partner at Brachers. I can see that we have people still logging in and coming into the session. Before I launch into today's half an hour on the Employment Rights Act 2025, as it now is, could I just do a little bit of housekeeping and just double check that people can hear me? And if you know how to metaphorically put your hands up or type into the question box that you can hear me, that would be great. Thank you. I can see a few hands coming up, so hopefully people can hear me. Welcome to today's session. I'd just like to make a quick apology. If you came to our last session on reasonable adjustments, due to technical difficulties that we haven't yet figured out, the recording got lost. So we weren't able to share that with you if you came to that, for our last session. That's why we didn't provide it. Hopefully we're recording today's session, so you don't need to write everything down. There will be a recording, there will be copies of the slides available should you want them. Touch wood, assuming we don't have a technical issue this time round, but apologies if you had that last time. So welcome to today's session. We're going to do as much as we can of the most important parts of the Employment Act, as you can cover in half an hour, because there is quite a lot of it and we won't get through all of it, I'm afraid. Okay, so without further ado, we will make a start. It is worth bearing in mind that what was the Employment Bill is now the Employment Act. It has been passed, it was passed just before Christmas. Okay, it is an amending act, it is an additions act, it adds provisions to existing legislation in the main. It is part of the Labour government's manifesto pledges and their plan to make work pay initiative. Okay, and it's introduced some changes in already, but they tend to be ones that don't affect most people, to do with minimum service levels and strikes, and they will introduce new measures throughout 2026 and into 2027. Okay, the act is what we call an enabling act, and what that means is it creates a framework that gives the government powers to then create a lot of the detail in statutory instruments. Okay, what that means is that a lot of the detail, a lot of the actual nitty-gritty information that you want is going to be in statutory instruments, which we don't yet have, unfortunately, in many areas. Okay, so I apologise for the fact that during this session we may well be saying quite a lot. We don't yet have the regulations, we don't yet have the detail. Okay, there are a number of closed and ongoing government consultations still about a number of these aspects that have been left to regulations. And until those have run their course, we won't have much of that detail. And that's still where we're at into March, albeit mainly for the proposals that aren't due to come in until October and or 2027. Okay, so we're going to look at some of the key measures, the ones on the slides: unfair dismissal, sexual harassment, third-party harassment, flexible working, protection for dismissal for maternity and other periods of absence, paternity, parental and bereavement leave changes, quick look at fire and rehire as a reminder, collective redundancy, protected disclosures, and if we get time, a summary of some union aspects. Okay, when you get the slides, there will be some other stuff on the slides to do with gender pay gap reporting, ethnicity gap reporting, that we just won't have time to go through in the session today. Okay, unfair dismissal is one of the major headlines. Much of this you may be aware of, but as the reminder, this is where we have now landed. At the moment, to bring an unfair dismissal claim, an employee needs, in the ordinary sort of unfair dismissal claim, 2 years of continuous service, and they have a right to written reasons for dismissal after 2 years of service. That's ordinary dismissal. In other words, not one of the dismissals that falls into all of the automatically unfair categories that we also have that apply from day one these days. When Labour were running to be in power, their promise was that they were going to introduce day one unfair dismissal rights. Employees would have these rights from the very first day of their employment, with a light touch probationary period, the details of which were never fully fleshed out. After the back and forth in Parliament, that has landed on 6 months for unfair dismissal rights. Okay, not 2 years, not day one, 6 months in, all employees will accrue ordinary unfair dismissal rights, in addition to the automatic unfair dismissal rights they still have in a number of cases from day one. Okay, the government has embedded this change in the actual act rather than a statutory instrument. Basically, what that means is it will be harder for a future government, should it not be a Labour government, to change that without a further act of Parliament. In other words, they've tried to make it harder for the next government, if it's not them, to undo that change and go back to a year or 2 years, for example. Okay, it's due at the moment, and everything when it comes to timetables for these changes is still at the moment, as far as we know, on the 1st of January next year. Okay, so anyone with 6 months service at that time, not 6 months from that time, but we think at that time, will suddenly have unfair dismissal protection. So you do need to start thinking about it in terms of people you're bringing into your organisations soon, because they will be the first ones to inherit this at 6 months, the turn of the year. Okay. Obviously, much shorter period to assess the quality of your employees. It will put pressure on whatever assessment or probationary period arrangements you have in place. The most common traditional 6-month probationary period will not work because they will have unfair dismissal at the point you decide they haven't passed their probation. So unless you are following a very thorough probation termination process, it's unlikely to be fair for an unfair dismissal point of view. So you will need to review how you do probation processes if they're based on 6 months. You will need to look at the contractual probation period you commit to if it's 6 months, because none of those are going to have the same effect that they've historically had. Will it lead to more people going to, say, temp to perm models? We shall see. Saying if I'm going to inherit them at 6 months, I'll use them through an agency for 6 months and try them out and then employ them for 6 months. We don't know. These could be the unintended consequences. But that is the key change. 6 months in, they will get unfair dismissal rights in the ordinary sense. And that means you do need to be aware of that risk and possibly take that into account in terms of the thoroughness of your recruitment processes, but also certainly the thoroughness of your assessment of the quality of an employee in the early months, which can be difficult because sometimes it takes several months to even train an employee up to do the job, let alone then give it some time to figure out if they're able to do it ongoing to a decent standard. So we're going to have to see how this works out. The other bit that came into these proposals that didn't get a lot of headlines because it wasn't part of the original manifesto, it wasn't part of the original bill, is the cap on unfair dismissal, which for years has existed as either a financial amount and most recently as the lower of 52 weeks gross pay or the financial cap of £118,223. So if you've got a £30,000 a year employee, it's £30,000. Okay, that cap is going to be abolished entirely. Unfair dismissal claims will become, at least in theory, financially uncapped. Okay, that is a huge change that did not receive a great deal of publicity or consultation because it appeared in the Act at the very last minute in the parliamentary process. Okay, so not only will you have unfair dismissal from 6 months, it is in theory financially uncapped in terms of the liability in the same way under, for example, discrimination claims are. It doesn't have a hurt feelings award still, like discrimination, but it does now have that no upper financial limit. Okay, all of the other caps on things like basic awards and so on, and the week's pay for redundancy, that's all staying the same, but that compensatory award is now going to be uncapped as of January 2027, we believe. Okay, that's a sea change. We're going to have unfair dismissal from a much earlier date and potentially much more expensive liabilities for unfair dismissal. I say potentially because just because you could now be awarded in theory as a £30,000 a year employee £90,000, most tribunals are still not going to be awarding those levels of loss. Okay, they're still going to be assessing what's a realistic future loss period, and I'm not sure we're going to see in practice massive increases, but it does make it somewhat more frightening when you're dealing with an unfair dismissal claim that could now in theory lead to a much more significant financial exposure. Okay, So just be aware of those risks going forward. Your dismissal processes are going to have to be sharper and more cautious and aware of the greater risks. Sexual harassment protections. Obviously, at the moment, an employer is secondarily, most commonly called vicariously, but technically secondarily liable for harassment by its employees in the course of their employment. Okay, so an employee commits an act of harassment, the employee is personally liable. Technically, the employer can be secondarily liable. Okay, and it covers obviously sex and sexual harassment in the sexual harassment bracket. At the moment, the law is that employers have a legal duty to take reasonable steps to prevent sexual harassment. That came in 2024 under the former government, coincidentally shortly after the Labour government announced their proposals to do so if they got into power. Okay, so the previous government said we'll introduce a new duty that says employers have to take reasonable steps to prevent sexual harassment of their employees in the course of their employment. Fine. What the Act says is that you will now have to take all reasonable steps to prevent harassment. Reasonable steps versus all reasonable steps. You might argue it's a semantic change, you might argue it's a substantive change. We'll have to wait and see how it develops, because to be honest, there isn't much in the way of definitive case law on what reasonable steps meant, because we've only had that for such a short period of time. Okay? There are powers within the Act to set regulations about what reasonable steps could be. We don't have what they could be as yet. Okay, we will have to watch this space. They will come into effect in theory at the moment in October. Okay, so as of October, there will be this, in theory, enhanced duty to take all reasonable steps to prevent sexual harassment. Whether reasonable versus all reasonable is any real difference, we'll see, but it is likely to raise employee expectations of the steps to which you will, take to prevent harassment in the workplace. How far are you expected to go? We don't fully know as yet, but obviously policies, training, education, and action when issues arise, which is what we mean by discipline and dismissals, actually taking positive steps to deal with problems if they occur. Okay, the one useful thing is it does now directly link to the defence in the Equality Act for employers that already exists, which is a defence to harassment or to discrimination claims, or particularly harassment claims, which is that the employer took all reasonable steps to prevent the harassment or harassment of that nature. So we now at least do have dovetailing between the duty, the standalone statutory duty to prevent it, which can be penalised for breaching, and the defence generally to harassment claims by an employee that they've been harassed, which is that you, as the employer, took all reasonable steps to prevent that harassment. The only challenge is the case law on when an employer has taken all reasonable steps is pretty hard to prove, and if they take that approach with the duty to take all reasonable steps, you're going to have a pretty high bar to get over. Harassment by third parties is one of the other big changes. At the moment, employers are not explicitly or directly liable for third-party harassment. There are complex legal arguments about whether you can shoehorn it within the existing legislation, but the general position is that you don't. Historically, there have been a number of cases that have looked at this, Bernard Manning case being the most famous one. Historically, we have had statutory attempts to cover this. We previously had the two-strike statutory rules that were then repealed. Okay, so we've had a history of back and forth on whether third-party harassment should be covered. The new Act makes it clear employers will be liable for third-party harassment, again, unless they took all reasonable steps to prevent harassment. The headline is, don't forget, this applies to all types of unlawful harassment under the Equality Act, not just sexual harassment. So you will have a duty to take all reasonable steps to prevent all forms of harassment by third parties of your staff. Okay, they are coming in October, which is now not that far away. What does that mean? Well, in theory, it means the risk of facing claims by your staff against you for failing to prevent harassment is obviously going to be a potential risk you're now going to have to deal with. We don't currently know what a reasonable, or rather all reasonable steps will be. Will it just be having signs up saying don't harass our staff? Will it be giving warnings to customers or clients or visitors or contractors? Will it be putting terms and conditions in any agreements with those parties? Will it be having a code of conduct that visitors, contractors, third parties, the members of the public all have to sign up to? How practicable is that in your environment? Is it going to be a site sign-in, like a health and safety thing that says, I agree to the site rules? And then what action are you actually going to take if and when incidents occur, particularly if it is your customers or your clients doing it? But also, what guidance are you going to give to your staff on how to bring third-party harassment incidents to your attention, or how to address them in the moment? Okay, those are all things to start thinking about if you don't already have stuff like that in place between now and this going live in October. Flexible working. Currently, right to request flexible working from day one. No presumption in favour of granting flexible working as such. You can refuse based on one of the 8 business reasons set out in the legislation, impact on quality, unavailability of work at the time they want to work, etc. At the moment, refusal can be largely subjective in the opinion of the employer, so long as that opinion, where it's based on facts, are based on true facts, correct facts. They don't just make them up. But generally, they have a large discretion to say no, because in their opinion as the employer, it won't work. Okay. Going forward, there is going to be a new requirement in the Act that flexible working request refusal thereof must be reasonable. That is an objective test decided on an objective standard by a court. Okay. So the 8 business reasons will remain, and the reasons for refusal must still be linked to those 8 business reasons, and the employer must state when refusing, in writing, in effect, what the reason is for the refusal and why they consider that to be reasonable. Okay, so employers are going to face a higher bar to say no to flexible working requests, and they are going to face, in effect, courts sitting in judgment of whether that refusal was reasonable, which includes assessing the reasonableness of their business reasons for saying no. Okay, there is an ongoing consultation on what the flexible working request process will be. Those of you that are familiar will know we've been through a few different versions of what the flexible request process should be. They are currently coming up with a new one, so we'll see what the actual process is. But the key is that you are going to have to justify to a higher standard why you say no. It's not necessarily gone as far as was originally rumoured, which would be there's an assumption that it will be granted that you almost have to overturn, but you will have to objectively justify why you refuse a request, which is going to make it harder in reality. Okay. Protection for maternity returners. At the moment, maternity leave, pregnancy cases, and certain people after maternity leave for a period of time have protection from, have special rights rather than protection when it comes to redundancy. So if you take the situation of a maternity person, if you make them redundant, they have a priority right over suitable available vacancies. Okay, so you can make someone on maternity leave or after maternity leave or during pregnancy, you could make that person redundant. It's not an absolute prohibition on doing that, but when you do so, they have this express first choice rights or first dibs rights on suitable available vacancies, if there are any. There's no obligation to create them. Okay, and that's how it sits at the moment. So they have this special protection, but it doesn't stop them being made redundant in many, many cases. Okay, what the Act does is it gives powers to bring in regulations to cover not only pregnancy and maternity leave, but also certain other forms of family leave, such as adoption leave, shared parental leave, etc. That's on the slide. And what it does is it gives, it brings in the potential right to ban dismissals of people on those forms of leave or who have returned within a set time period from those forms of leave. Okay, so we think, because we don't have the detail yet, that it will ban dismissals possibly during a 6-month period after their return to work, except in specific circumstances. Unfortunately, we don't yet know what those specific exceptions from a ban on dismissals will be. Presumably gross misconduct, for example, would be one of them. Presumably closure of the whole business or the whole site would make sense, etc. But we will have to wait and see what the exceptions will be from the otherwise prohibition on dismissing, in effect, most commonly people on maternity leave or who have been on maternity leave. Okay, there was a consultation that closed on the 15th of January. We don't yet know what actual, therefore, regulations will come out of that in terms of proposals. At the moment, we think these are not going to kick in until the start of next year. Okay, so it will become harder to terminate people who've taken these forms of leave, who are on these forms of leave, but how hard, we will only know once we see the final regulations. Okay. We don't yet know if this protection will survive a change of employer if someone moves jobs. We'll have to wait and see what's in the regulations on that point. Bereavement leave. There is no general statutory right to bereavement leave at the moment. There is no entitlement to leave for pregnancy losses that occur before 24 weeks. We have statutory parental bereavement leave and pay, but that applies to someone whose child dies under the age of 18 or is stillborn after 24 weeks of pregnancy. There are also separate rights to unpaid reasonable time off in certain circumstances under emergency dependence leave. The government has put a power in the Act to introduce a day one right to at least 1 week of bereavement leave for employers, currently not proposed to be paid. Okay? Regulations will specify the connection, i.e. how close a family member it has to be for the right to apply. The right also applies to pregnancy loss before 24 weeks of pregnancy. So we will have statutory bereavement leave for relatively short periods unpaid, expected from the start of 2027 at the moment. Probably going to have a pretty limited impact. Looks like it's going to be a short period. Looks like it's going to be unpaid. Many employers that I know already offer some form of bereavement leave, in many cases that's paid, that will probably exceed these new entitlements. But you will need to be aware of it. You will need a new policy. You will need, a procedure for dealing with these requests once we get the detail of the regulations. Parental leave, very quickly. At the moment, to be entitled to parental leave, which is the right to 18 weeks unpaid to look after children, you have to have been employed for 1 year to be eligible for parental leave. The Act removes the requirement for length of service. You will be entitled to parental leave from day one. That means this is due to come in on the 6th of April at the moment, 2026. It's showing on the government website where it explains eligibility as that's what's happening. So that looks pretty certain to occur in the next few weeks. If you have parental leave policies, they will need updating to reflect the fact that there is no requirement to have a year's service anymore. Do we think it's going to suddenly lead to a massive increase in parental leave? Probably not. The experience is that the take-up of these rights are not huge. It's still unpaid. You still have to follow the same notification requirements. We'll have to wait and see if it leads to a significant increase in people taking that form of leave. Paternity leave, again, eligibility for this requires at the moment 26 weeks of continuous employment assessed at 15 weeks before the expected week of birth. And they lose entitlement if they take shared parental leave before getting round to this type of leave. Okay, and this is the paid up to 2 weeks that people can take at statutory paternity pay rates. Again, the Act removes the length of service. There will be day one rights for paternity leave, and they will be able to take it after they've taken shared parental leave and pay. So again, policies and procedures that govern these areas will need to be looked at and updated in the next couple of weeks, because this is also due to come in on the 6th of April. Again, will it be, other than those updates, will it have a material impact? I don't think so. I'm not sure that it's going to lead to a massive increase in the amount of people taking paternity leave across an organisation, but we'll have to watch this space. Okay. Fire and rehire, very briefly. I just want to cover one thing that's not on the slides, which is, of course, statutory sick pay is going to become a first day of absence right, as you know, as many of you will come across. So people will be entitled to statutory sick pay from day one, not from day 4, with the 3 waiting days. be aware of that and those changes. I can't off the top of my head remember the date they're due to come in, but also be aware that for statutory sick pay, we will be removing what's called the lower earnings limit requirement, and people who earn below the lower earnings limit, who don't currently qualify for statutory sick pay, will now qualify for a modified form of statutory sick pay based on 80% of what they actually earn, okay? Because it's lower than the statutory sick pay rate. So be aware, obviously, changes to statutory sick pay are also coming. Fire and rehire very briefly, because it doesn't apply to most people most of the time. But at the moment, we have a code of practice that says you have to jump through certain hoops before you can carry out dismissal and re-engagement to change terms and conditions of employment, okay? It is currently still lawful to do it, albeit it's had a bad press, let's say, over recent years. But it can be a very useful tool for employers to change terms and conditions in order to help a business continue to succeed. It's not always about just making more money, okay? We are going to see in the new Act a significant restriction on the ability to dismiss and re-engage to effect changes to terms and conditions of employment. In effect, except for certain excluded variations, we don't have the detail yet, but they might include things like shift patterns, working hours, certain changes might be exempt, but generally speaking, dismissals with the offer of re-engagement to effect changes to terms and conditions will become very, very difficult, almost nigh on impossible, unless your business is going bust. And by that point, probably too late to be doing it, okay? So we will have a legal prohibition that says you cannot dismiss to effect changes to terms and conditions except for limited circumstances, possibly things like benefits schemes, unless your business is in effect, it's being threatened as its survivability as a going concern, and there are no other options to avoid doing this. It's going to become very difficult. It's due to come in at the end of the year, we think. What I would say is if you're operating on contractual terms and conditions that aren't really working, you've got until the end of the year an easier, I wouldn't say easy, but an easier opportunity to try and change those terms and conditions if you have to, than you will have next year. What I would also say is if you are preparing new contracts, if you are drafting new contracts, think carefully about the degree of flexibility that you're building into them, because flexibility built into the contract is not a variation of the contract if you use it, but if you draft narrow contracts, changes to those contracts become contractual variations and you will run into difficulties with these new rules, okay? Collective redundancy very briefly, currently 20 at one establishment, so 20 or more proposed redundancies by reason of redundancy at one establishment within a period of 90 days triggers the requirements. The penalties are up to 90 days pay per affected employee. If that's 100 people, that can get very expensive very quickly. Okay, but it's limited to, in effect, one site, one location, 20 or more at that location. Okay, we're going to have a new company-wide threshold that's not just about the location. It counts the number of proposed redundancies across the whole organisation at whatever site. The current consultation indicates that is likely to be based on a fixed number, probably between 250 and 1,000, which means for many, many people it will never become a relevant issue. But if you are a large-scale employer who make regular redundancies across multiple sites, you're going to need to keep an eye on what the numbers are adding up to in order to avoid triggering the new rules. The other sting in the tail is that the protective award is going to increase from 90 days to 180 days per affected employee, which is potentially makes it an already significant financial risk even more significant. We may, it's not yet clear, also see a return to 90-day consultation minimum periods for 100 or more redundancies rather than the reduced 45 days we have at the moment. It's 30 days for 20 or more up to 99. Okay. Qualifying disclosures, I'm just going to not worry about because it's not too much, but you can read it in the slides. The last bit I just want to cover before I say thank you for today is union access. At the moment, there's no general right for trade unions to access a workplace. They can ask to come on your site to talk to your staff about being in the union, about union stuff, but you don't have an obligation to allow it unless you have a collective agreement with that union in which you've agreed to do so. Okay, there are very rare circumstances where they can order it as part of a compulsory recognition process, but they're incredibly rare. Going forward, trade union officials will have a right to access to your workplace. This is both a physical and a digital right of access for the purposes of recruitment, organising, but not organising industrial action, and collective bargaining purposes. There will apparently be a prescriptive statutory process, but trade unions will have the right to approach you, even where they are not recognised by you, and ask for the right to access your staff either physically or virtually for those purposes. Be aware of it, because I suspect many employers will dismiss such approaches without being aware it will now breach a statutory obligation requiring you to enable this within a set of rules that, unsurprisingly, we don't yet have. Okay, it'll be interesting to see how much the unions try to use this and how many employers are then approached for this sort of access, but be aware there will be this statutory right to say we want to come on your site, we want to meet your staff because we want to recruit them. Many employers' response to that at the moment would be no, go away, but that's going to now have to change because of these new rules. Okay, and they're due to come in October 2026. It's a very whistle-stop tour of some of the key aspects of the Employment Act. As I say, when we share the slides, you will see there are other materials and other topics that we cover that we just don't have time to get through in half an hour today. So please have a read. They'll give you some insight into the other wider changes that are due to come on stream, most in October or most from January, we believe, next year. Someone's asked about 2P, the two-tier code. The measures that we know about in terms of the 2P rules on outsourcing to the public sector, there are slides in the slides that will come out addressing the quite scary, if you're involved in taking outsourcing from the public sector, new rules on matching pay terms and conditions from the public sector, not just within those transferring from the public sector to you, but also those that you employ that are going to work on the work that's come from the public sector to you. If you're involved in public sector contracting, you do need to be aware and keep an eye on how those rules finally wash out, because they could have quite a significant impact. Thank you for attending today. Sorry I've run over by 3 minutes. I hope it's been of some use as a very brief reminder of where we got to with the key provisions of the Employment Act. If you have any questions, please reach out to us. If you want any further information, we are going to be putting stuff out on our website and through our channels to provide follow-up to this information as we go through the rest of this year. Otherwise, I will take up no more of your time today. Thank you for coming, and I look forward to speaking to you again on one of our future events.